welcome to this webinar on criminal tools for fighting fraud for high net worth and family office clients. Over the next 60 minutes, we're going to bring you three experts who can help you understand how you can help protect your clients better, the tools available. As always with PCD content, we love to hear from our audience. We've got an international list of attendees signed up today, tuned in live on YouTube from the Channel Islands, Isle of Man, Switzerland, and further afield. So delighted to have you all with us today. As I mentioned, we've got three expert panelists. We have Kyle Phillips, who's a partner from Hare Kennedy in London. He's a specialist financial crime and regulatory solicitor. Great to have Kyle with us, who proposed this session in the first place. And we also have we're also joined by Brendan Weeks, who is Associate Director at Smith & Williamson in London. Brendan is a fraud and forensic investigator, so adds a different perspective to Kyle on the legal side, really crunching into the numbers and looking at the investigative side. So really interested to have Brendan here. And last but not least, we have Christopher Coltart QC, who is Head of Business Crime and Financial Services Group at 2 Hare Court, who's a specialist barrister, often instructed by solicitors representing their clients. So welcome, gentlemen. Great to have you on today.
Thank you, David. Thank you for having us.
Before we get underway, you proposed this session for our members, which is really interesting and has had a great response. It'd be interesting to hear a little bit about the type of clients you work with, some of the ways you get instructed, and why it's relevant for private wealth advisors to have a knowledge of this area. Yeah,
so we had a discussion, David, a while ago about just sort of the kind of cases that I do, and it just seemed to be quite relevant, given that a lot of the cases I do are for investors, individuals, high net worth individuals, entrepreneurs, businesses, a whole array of individuals and corporations, etc., who are becoming the victim of fraud on a more frequent basis, I think, than ever before, with different array of types of frauds that are being committed against them. And so it's a real difficulty for them to understand what they can do about it, particularly given, as we'll go on to discuss, some of the issues that are out there at the minute that are preventing law enforcement from doing thorough investigations. We get approached from advisors to a lot of companies, tax advisors, business advisors. We also get approached by other lawyers, employment lawyers, corporate lawyers, family lawyers, people who advise these individuals and who know that we've got a strong reputation in the field and can assist them and help them, as well as by victims themselves.
Has the pandemic escalated some of these trends? I mean, it's widely reported in the sort of more retail or regular person is more subject to fraud, scams, tech, different campaigns that are out there. Are you seeing that also translating into the high net worth space over the last 2 years?
I think that's right. I think what's happened is that the type of fraud, so a lot of it's becoming sort of very electronic now. A lot of it has moved from being frauds that are committed sort of face-to-face, so people going into places and, for example, identification frauds, to more online, people using technology and approaching people through emails, scams, investment frauds. And again, all through the online sphere. So not so much the sort of Ponzi schemes that you might see, for example, by people creating these sort of platforms for people to attend, meeting face-to-face, go and sell a product, which is effectively a fraudulent product. But it's all being done now through the internet, which is becoming a big issue. And because of that, I think there's more access for people to be able to take advantage of certain individuals on a greater scale. So I think that's why we're seeing a big increase.
And I guess both high net worth and family office clients looking at their security in that to prevent perhaps some of these things coming to the fore, but you're there to fix things when
exactly that. So
there do slip through.
Many things that can be done to prevent it in the first place. The talk today is really to discuss and give people a good feel of, or an understanding that when these things do happen, you might feel very powerless. And what we're trying to do is equip you with these sort of thought processes and things that actually you can do if you act quickly, and things that people might not necessarily already be aware of.
Fantastic. Well, look, do put your questions in the chat as we go through. We're going to hear from Kyle, from Brendan, and from Christopher, and then open up in the second half really for more questions. So plenty of time to get your questions in the chat. I'll bring them back onto the speakers. But Kyle, if you want to open up with some thoughts, then we'll get underway.
Thanks, David. Yeah, I mean, I just wanted to start the ball rolling. I mean, what we want to do is to try and encourage as many people to come forward with questions throughout. We really want this to be a sort of a two-way exercise. Myself, Christopher, and Brendan have got quite a lot of experience dealing with a whole array of frauds, and between us, we're fairly confident that whatever scenarios you have thought about, we will have dealt with in the past, whether it be, being a victim of fraud, representing someone who's been a victim of fraud, using the police, going through what we call action fraud, any sort of experience that you may have. It'd be great to hear from you on this chat. One thing I think we can probably all agree on is that fraud is prevalent, but I'm just wondering if you understand quite how big fraud is in terms of an issue in the UK alone, as well as on an international scale. But in the UK alone, most frauds count for sort of 30% of all crimes that are reported to the authorities, which is a huge amount when you think of all the other types of crimes that can be reported, from your sexual offences to assaults, etc. 30% of that is accounted for by fraud, and it's estimated that costs the UK economy £137 billion each year. Now, they're the frauds that are known about as well, because there is a bit of a stark contrast in the amount of frauds that do occur to the amount of frauds that are actually reported. I think there's been a sort of drop in individuals approaching the authorities who are victims of fraud now, because a lot of people do feel helpless. And the NCA, National Crime Agency, recently published a report that suggested that only 20% of frauds are actually reported. And given that what we're talking about is figures of about 4 billion frauds that they reckon happening every year, that's a very small percentage of frauds being reported, and so many of them slipping under the radar. So it is huge. Fraud is massive. And I would almost guarantee that nearly every person on this has been touched by a fraud in some way, whether or not they are the victims themselves, their families are a victim, or whether they've just been approached and managed to, prevent the fraud from going through. We all get these scam emails, HMRC emails, all these things are happening, but particularly in businesses as well, where you're even more susceptible to these frauds. And as we said before, we've seen a big upsurge in frauds during the pandemic. What we saw was a 24% more frauds reported in 2021 than there were in 2019. That's quite a significant leap. And what we've seen is, like I mentioned before, the type of fraud, the digital types of fraud, we're seeing a big increase in them. So internet banking fraud is up by 117% on previous years. Remote banking fraud up by 48%. Apologies as I look down during this time, but my stats are there. Investment fraud up by 32%. Romance fraud, so people coming from abroad and trying to take advantage of individuals, that's up by 38%. So a significant increase in numbers in the amounts of fraud that are happening, and targeting not just companies, but individuals as well.
Do you find that the private banks have the infrastructure in place with dealing with the ultra high net worth clients on the callbacks, the type of measures they can take place, knowing their client and being an overlay?
You would think so. But a very recent case that I did was exactly that situation, where somebody called up and it was a trust, and they effectively convinced the private bank that they were the trustees and moving the funds to the beneficiary. And it was about £15 million that were being transferred. And they managed to do it by convincing the bank that they were somebody else who had the authority to do this. And I think because of the relationship that was between them, I think the people on the other line felt a bit more comfortable that they didn't have to go through the necessary security checks that ordinarily be done. Now, this was a good case of where they did come to us to help, because the banks, once it was reported, were able to use their systems and procedures that they have in place to contact all the other banks who are involved in the chain of the money. And each bank would then, like a domino, go around and keep following the money. But a lot of these fraudsters will move this money to one bank and then quickly disseminate it to many other banks. And the trick is to try and get there as quickly as possible. So the banks moved as quickly as they could. They secured 4 million, but through the powers that we have, through investigations, through civil courts, Norwich Pharmacal orders that we can talk about a little bit later. I don't want to go into the sort of the legal ins and outs of it, but the position is that there are powers there that can be used that the banks will not necessarily do, because they'll do what they can, where we can go above and beyond what they can do. So, in answer to your question, even when there are the private banks or other banks involved, doesn't necessarily afford you that comfort. Although, there is at least some protection there, and where the banks have done something wrong that they ought not have done, they really ought to be covering you for the losses suffered. But that can lead to, significant litigation and, a long-term sort of solution that's very, very stressful. Whereas what I'm proposing here is there are other avenues as well that can be followed to try and recover the actual money that's been lost, as quickly as possible.
Excellent.
So just coming on to that, people will report matter. I mean, the first point of call is always to report the matter to your bank as soon as you find out, because you need, things to be closed, and the banks do have procedures in place where they can contact the other banks. They have these emergency messages that go with the other banks and can start tracking the money immediately. I wonder if any of the listeners have actually tried to report the matter to the authorities before, and if anybody's actually been successful. It's estimated that sort of less than 1% of all the police personnel or enforcement personnel are involved in fraud investigations. There's really been a cutback in the amount of facilities, the amount of resources that are available to investigate fraud. Some may argue as well, and there have been certain articles out there to say that actually now there's no better time to be a fraudster than right now, because the resources have been placed elsewhere, particularly during the pandemic. But let's not kid ourselves, this was happening before the pandemic, where resources were being pulled away from the police, taken out of the enforcement agencies. You have the other enforcement agencies there, so the SFO, the FCA, the NCA, but there's this real sort of gap where the SFO, for example, deal with serious and complex frauds, generally over £1 million, to anything below that, which is what we see on a very frequent basis, and nobody really taking responsibility for who is reporting and who is investigating and prosecuting those matters. What we've seen is statistics from, say, 2010, where 1 in 500 frauds resulted in prosecution, and that dramatically got worse over the last 10-year period, where up to 2022 it was 1 in 1,000. So only 1 in 1,000 frauds were reported actually get any sort of prosecution done. So there's clearly a deficient response by law enforcement to fraud, and this can leave a lot of people feeling very helpless when frauds do occur. And that's what we're here to talk to you about, because what we have been seeing is an uplift in the resources that are available through solicitors, and that could be, for example, through civil action. But what we're here to really talk to you about today is powers that you might not necessarily be aware of, and that's private prosecutions, which are becoming even more popular and being used more and more frequently over the last few years. And common sense will probably tell you that one of the main reasons for that is because of this lack of enforcement that's been happening elsewhere. And just it's all about getting justice.
Carl, we've got a question in the chat just asking, what tends to be the cutoff point for police to investigate from your practical experience? So I suppose if they got this huge backlog, what's the cutoff? I'm going to assume that's in relation to fraud. So what the police have been told is that they must prioritize other types of crime above fraud. So domestic assault, etc. Particularly during the COVID pandemic, there was guidance that was passed down that was agreed between the Crown Prosecution Service and the police that stated that the priorities for charging during that time were all these other offences, and way, way, way down the bottom was fraud. But when you talk about the types and nature of the cases where police might get involved, it really depends on the circumstances. So it's not always just about the amounts involved. You might be looking at who the victims are, how this came about, whether or not they're susceptible to it happening again, whether the people who have committed the offence are easily identifiable. So there's a lot of issues to take into account there, where the police will look at it. But there are a lot of occasions where the police will just turn around and just say, well, you know what, it's a fraud. Sounds more civil than criminal, so we're just not going to bother. The truth is they just don't have the resources to look into anything that is really difficult, that isn't going to cause somebody serious harm in the short term. So it's just about trying to prioritize and then look at each case on a case-by-case basis.
And David, just jumping in there for a moment, if I may, just to give an example of the reluctance of the police perhaps to intervene these days. I acted about 2 or 3 years ago for a hedge fund, which had been the subject of a large-scale theft by one of its employees who'd stolen about £3 million from the company over the course of a 10-year period. And having discovered this, the company investigated and instructed a firm of forensic accountants to come in, recreate the audit trail, produce an all singing, all dancing, very comprehensive forensic accounting report, which the company then took to the police and said, well, look, here you are, it's gift wrapped, it's overwhelming from an evidential perspective. All you've got to do now is investigate and prosecute. And the police said they didn't have time or the resources to prosecute that matter. So the company then sued the employee for the return of the money. And in the course of the written exchange of documents in the civil proceedings, the employee admitted the fraud. So she actually admitted it in black and white, it was in writing. So the company went back to the police at that point and said, right, here we go. You've got the report, you've got the confession. What more do you need? And they said, we haven't got the resources to investigate or prosecute this matter.
Wow.
Which is why I ended up conducting a private prosecution on their behalf, which resulted in a guilty plea and a 4-year prison sentence. So, I mean, we're going to come and talk about private prosecutions in a moment. But if the audience is interested in the level at which you need to try to engage the police, it's extremely difficult at the moment because they're just not interested in prioritising other matters.
Thank you.
If I could add something in defense of our fellow law enforcement colleagues. I had a matter where a bookkeeper had stolen 40,000, which in the grand scheme of things is hardly anything. A certain constabulary, local policing authority, took an interest in that and went from action fraud all the way through to interviewing the suspect and prosecuting the suspect within the matter of months. So there are good stories. I think we just need to bear that in mind, but there are plenty of bad stories as well. So
I must say I'm pleasantly surprised by that, Brendan. In my recent experience, that is very much the exception rather than the rule.
Absolutely, yeah.
I think that especially with the directive that Carl was talking about a minute ago, the CPS handed down to the police really in the early days of the pandemic, within a few weeks of it breaking, that they were to prioritize other crimes. And we've got a copy of the document somewhere that was circulated to the police, and it makes for pretty sorry reading, to be honest. But there we are.
There is a good question there, David. I don't know if you want to read that off. You're happy
just to say, what's the is it better to go to a specific authority?
It's a good question because I think one of the, and I don't know if Chris and Brendan, you agree with me on this. I think one of the issues is no authority really knows or has taken responsibility for these low level frauds. So it's actually probably, it's not. I mean, we would advise them probably go to the police in the first instance, but they're all sort of looking at one another. So the police will look at the SFO and go, well, it's a fraud, so you're dealing with it. The SFO will go, well, it's too small for us, so the police are dealing with it. The FCA will go, well, it's nothing to do with our remit because it's not financial services, so therefore it's not yours. I'm not even sure what the NCA do these days, if I'm being honest with you, apart from maybe looking at PPE. I know they've been contracted to that, but it gets very confusing as to who is to deal with what. And I think actually the authorities themselves don't fully understand who is meant to take responsibility for what type of nature of investigation. We used to have specific fraud teams set up within the police force. A lot of those have been disseminated. There is one, I think, still with the City of London Police, but it's so small and so under-resourced. It's frightening. And it's almost that every single fraud that is reported is being told to do so through this action fraud website, regardless of where it is. And then they're meant to disperse it to whoever is the correct authority. That's what you're encouraged to do. But that just goes to a desk in the City of London Police, to this National Fraud Investigation Bureau, where what it feels like, and we can't say for sure, but certainly what it feels like is they'll grip onto any excuse that is available to them in order not to investigate it. And that's certainly the experience that I've had with my clients. And I'm guessing, Brendan and Chris, you're seeing similar to that as well.
Yeah, and it's a great pity because actually the City of London fraud squad used to be really, really good. So
yeah, they were brilliant.
They were brilliant. 10 or 15 years ago, they were well resourced. They had very experienced detectives working on their team, and they routinely used to get results, and they would generally always investigate. But in fact, it was the horror story I told a minute ago about the company that had been defrauded. It was to the City of London police that they went to try and get the police to investigate. And it's the sort of case that 15 years ago, the City of London police would have bitten your hand off to take it on, and they were simply unwilling to do so. So it's difficult. It's very difficult at the moment. But there are remedies, which I think is. Should we come on to that, Carl? I don't know whether
I think we're right on that point. I think there was a good segue almost before that we kind of missed. So should we go straight to you on the remedy?
Yeah, sure. Okay. I mean, I say it's a remedy. It's not a cure for all ills, but as Carl mentioned earlier in his introductory remarks, private prosecutions have become very popular over the course of the last 10 years, particularly in this sphere of fraud, large-scale fraud, where companies and individuals who've been the victims of fraud and who have been unable to obtain redress through the police have turned instead to instructing lawyers to prepare and conduct on their behalf private prosecution. So I thought, David, what might be helpful is just to spend, I mean, it's a topic, frankly, we could devote several hours to, but to put everyone's mind at rest, we're not going to do that. I thought I'd give a very high-level overview in just a few minutes of what a private prosecution is and how it works. So it's a right. The right to bring a private prosecution is enshrined in English law, has been for a very, very long time. And the short answer is that anyone can bring a private prosecution, companies, individuals. That there are some limited exceptions to that rule. So, for example, there are some offences which can only be prosecuted with the consent of the Attorney General or with the consent of the Director of Public Prosecutions, for example. But for most fraud cases, it doesn't apply, and it would be open in theory for anyone to bring a private prosecution. You don't need the permission of the police. You don't need the permission of the Crown Prosecution Service, although for reasons which we'll come on to when we have a look at costs and cost recovery, it's wise to involve the police or the CPS at the outset. But you don't actually need their permission to take action. In terms of the mechanics of starting a private prosecution, it's relatively straightforward. You apply to a magistrate's court. In London, it's usually Westminster Magistrates Court for a summons. And what that involves is submitting to the court details of your complaint. And if you've instructed lawyers, ordinarily they would prepare a case summary setting out the basic facts of your complaint, the way in which you've been defrauded. You would submit that to the court along with a schedule of the proposed charges which you're planning to bring against the putative defendant, and you would then ask the court to issue a summons. And if the court is willing to do so, then that summons is served on your prospective defendant, and provided that the defendant is within the United Kingdom, then the defendant will be compelled at that stage to be at court on the day specified in the summons, which won't actually be for the trial. It'll be for a sort of preliminary hearing, administrative hearing, but defendant has to be there, has to answer the summons, and then the procedure starts. And then it unfolds in much the same way as any normal prosecution would unfold. In terms of matters which the court will take into consideration in deciding whether or not to grant your summons, there are sort of some basic requirements. The offence must be one which is known to law. That's the rather pompous phrase which is used by the profession, but basically, is it an offence that everyone recognises exists on the statute book? Are the ingredients of it made out? Are there any other barriers to the prosecution? Is it time barred, for example? There is time limits in relation to some offences. Does the court have jurisdiction to hear it, etc., etc., etc.? And provided all of those things are met, then the summons will be issued. And needless to say, if you have retained lawyers on your behalf to conduct the private prosecution for you, then there shouldn't be any question of this stage of the proceedings not being made out, because you should have been advised, yes, an offence has been committed, there's sufficient evidence to support it, and so on. A really important power which exists in the hands of the CPS, however, is to take over and discontinue a private prosecution. So this happens quite often in relation to crackpot private prosecutions, where one neighbour prosecutes his next door neighbour for I don't know, growing his plants facing in the wrong direction, or whatever the nature of their daft borderline or boundary dispute. That sort of case is taken over by the CPS and discontinued, because it's simply not in the public interest to have cases of that nature being prosecuted through courts which are busy and overstretched and underfunded, particularly in the current environment. So the CPS have that ability, and quite often defendants who are on the receiving end of a summons from a private prosecutor will write to the CPS and invite them to take it over and discontinue. But again, if you've instructed a competent legal team, then there shouldn't be any danger of that happening, because the team should have made sure that all the proper boxes have been ticked before deciding whether or not to prosecute. Just in terms briefly of how a private prosecution differs from other litigation which your members may have been involved in, because I suspect that one way or another, given the field in which they operate, a lot of your members will have been involved in some form of litigation at some point or another, mostly civil litigation. In civil litigation, it's fought very, very hard. The parties play their cards very close to their chest. No quarter is given. There's almost no trick too cheap. I mean, there are some rules which have to be followed along the way, but it's pretty bare knuckle stuff. It's a different mindset as a private prosecutor. You are so-called a minister of justice, and what that means is you have a responsibility and a duty, a legal duty, to ensure that the case is prosecuted fairly and reasonably, because someone's liberty is at stake. And so it's absolutely essential that things are done by the book. That particularly applies in the realms of disclosure, for example. So if the private prosecutor has material in his or her possession which hasn't previously been provided to the defendant, but which is capable of either undermining the prosecution's case or assisting the defense case, then that material has to be disclosed to the defense. Now, that's a notion some clients find quite difficult to begin with, because particularly if they're used to having engaged in civil litigation, where although there is a similar approach in some respects, I'm not sure it's honoured in quite such a stringent way. But in prosecution cases, it's vital for clients to understand from the outset that if there's stuff in their possession which is unhelpful from their perspective and therefore almost bound to help the accused, then that material all has to be disclosed. Let me just touch briefly on costs then, because that's a subject which is close to everybody's hearts, albeit perhaps for different reasons. Private prosecutors will generally recover their costs, is the sort of strapline, I suppose. If the defendant is convicted, then the prosecutor is ordinarily able to recover his costs. In the first instance, they should be sought from the defendant, but if the defendant, as is quite often the case, is not in a position to pay those costs, particularly if they've been carted off in the prison van at the end of it, then it's possible for the prosecutor to have their costs reimbursed through what's called central funds, which is effectively a government pot of money that's used for this purpose. I said a little earlier in my introductory remarks that although you didn't need to involve the police in seeking permission to launch a private prosecution, it might be a good idea to do so. And the reason for that is that if a private prosecutor does embark upon a prosecution without having first invited the police to take it on, then the prosecutor's cost recovery is likely to be capped at a much lower rate than if it's been offered to the police and they've rejected it. So in a big complicated case where the cost could be significant, that's obviously an important consideration for clients. So whatever else happens, at least offer it to the police, pretty secure in the knowledge they won't take it. But once you've done that, then you're covered, as it were, from a cost perspective. Even if a defendant in a private prosecution is acquitted, then ordinarily the prosecutor will still get a costs order at the end of the trial, provided that the court is satisfied that it was proper to bring the case in the first place. So if the judge thinks, well, it was a perfectly sensible case, the jury didn't convict, but that's what happens in jury cases, I'm nonetheless going to give you your costs back, Mr. Prosecutor. There is a word of warning in there that if a really poor prosecution is brought, which should really never have been brought in the first place, and as a result gets kicked out by the court at some point, or if the jury acquit in circumstances where that had become inevitable, then it's possible for the defendant in those circumstances to apply for his or her costs from the private prosecutor. So that's worth bearing in mind. But again, at the risk of repeating myself, provided you've got a competent legal team behind you, you should never be in a situation where you're bringing a hopeless case in the first place. So, but I mention it for completeness. And finally, at the risk of finishing on a slightly sour note, it's true to say that Parliament has got the cost regime very much under close scrutiny at the moment. The Ministry of Justice is firmly in favour of capping the rate at which private prosecutors can recover their costs, possibly down as far as legally aided rates, because they're concerned at the size of the cost orders which are being made in favour of private prosecutors at the moment. I mean, you can understand the logic of that, but the problem is that where does that leave people who've been the victim of fraud? They're either in a situation where they've got no recourse through the police or the Crown Prosecution Service because they won't take it on, or they're in a situation where they can't afford to bring a private prosecution because they're worried about the rates at which they're going to get their costs back. So it's a very, very unsatisfactory situation, and we'll just have to see how that turns out.
That's in early consultation, though, isn't it, Chris? We're part of
yes.
that because we're on the Private Prosecutions Association, and early consultation. There are a lot of issues with it, but you basically wherever the government can make cuts, they'll look.
Well, they will, and if lawyers are involved, then so much the better.
There's a question on email there, just asking, it's coming via email, just asking if you carry out a private prosecution, what happens to the recovery of money? So if the judgment's been passed down, what's the next step in terms of someone's been defrauded? How do they get their assets?
Chris, do you want to deal with compensation and confiscation? Then I can look at the civil sort of side of things. Would that be?
Exactly. I was going to wrap up with this. I'll tell you what, David, I'm going to do. I'm just going to make a few sort of closing observations, but in the course of that, I will deal with that particular point because it was on my sort of list of things to deal with anyway. I mean, if you're looking generally at a sort of balance sheet in terms of what are the pros of a private prosecution on one side and what are the cons of a private prosecution on the other side of it, then the advantages are generally it's quicker and it's more efficient than trying to deal with the police and the Crown Prosecution Service, who are overburdened and under-resourced. You get a free rein of your choice of representatives, which can be important. And it's also an opportunity to secure what might be loosely termed as justice. So, for example, the company I mentioned earlier was largely pursuing the employee who'd stolen all that money from them because they felt it was the right thing to do. And also they wanted it to act as a deterrent to anyone else who might be considering doing the same thing. So those are all important considerations and advantages. But the downsides can be the potential cost, as we've just been talking about. A certain lack of investigative firepower, which we might touch upon a bit later, I suspect, with Carl and Brendan. But also is this point, which arises then in relation to the question that's just been posed, is that if your primary ambition at the end of a private prosecution is simply to recover the money that's been stolen from you, then private prosecution isn't necessarily the most efficient way of going about it. So although it is open to private prosecutors to secure confiscation orders from a convicted defendant, in other words, to remove from them their ill-gotten gains, and although the courts are able to make compensation orders in favour of people who've been defrauded and payable by a convicted defendant, if your sole ambition is to get the money back or to stop it from disseminating even further, you're better off going down the civil litigation route because it's just more nimble and it's more agile, and you don't have to secure a conviction to the criminal standard against someone before you can put those processes in train. So it depends very much what you're after. Private prosecutions are perfect, really, if what you're after is justice, deterrent, retribution, and to an extent, the recoveries of monies. But if actually it's all about the money, then instruct your civil team instead.
I would agree on that. Just take it one step further, what you can obviously do is to bring parallel civil and criminal proceedings. So that's an option which a lot of our clients do. So on the one hand, they're looking to seek the recoveries and to seek the recovery of their money and to protect themselves financially using the civil regime. But on the other hand, they want to set a deterrent. They've had somebody come in and effectively take money from their business. They don't want that happen again. It's got out there. So they want to really sort of send a clear message to the market, or the person that they're up against is a fraudster. They want to make sure he's being punished. So they want justice to happen as well. So that's why we say if it is just about the money, not necessarily the right vehicle, but if it is more than that, then it's quite often worth having to think about.
And on the recovery, I guess if there's an international dimension, if those money's gone cross-border, that adds another complexity, does it, onto your job of trying to recover?
It does, but fortunately through the civil, so we work quite closely with our civil team in relation to things like this, but we have a huge menu, as we call it, of tools available for the recovery of the losses of the proceeds of crime, etc. For example, worldwide freezing orders that can be brought and obtained in the UK and apply in many jurisdictions worldwide. So it does get very complicated, but there are the tools in the UK to deal with that, probably more so than many other jurisdictions.
Okay, excellent. Kyle, did you have anything to add on to Christopher's opening comments, or should we?
I didn't. I thought what would be helpful would be to hear about a couple of practical examples, which Brendan's got two, I believe. But if we can talk through those examples, I think it might engage some good discussion. Right. And so should we pass over to Brendan?
Thanks. I suppose just to kind of give another flavor of private prosecutions, Macmillan Cancer Trust is one of the charities that often bring private prosecutions. And I think they are generally good news stories. So plenty of press about them. It's basically where people have been raising money on behalf of Macmillans and then keeping the money rather than passing that over. So lots of sort of positive press about that. The two examples that I wanted to kind of just hopefully rush through. One is an internal fraud where private prosecution might have been a better option. And then another is an external fraud where private prosecution is the preferred route, and hopefully touch on some of the points that have been raised, motivation for bringing that prosecution being one of the key things. So the first example is a suspect working at a family-owned hotel chain out in the regions, not in London. And Mr. Suspect had been in a senior position at that hotel for a number of years, almost up to a decade. And as you get with those sort of internal frauds with those people in senior positions, you've got this sort of blind loyalty, blind trust. And no one actually questioned any of the activities, even if they might have looked a little bit strange. It was always the case of, well, Mr. Suspect has been here for ages. He knows what he's doing. But while he was on holiday, the staff that was covering discovered money missing. And there's a couple of steps that you need to do when you first sort of start suspecting a fraud. I don't want to get into that, but happy to kind of chat about that later. But discovering a little bit of money going, doing your investigation, and then all of a sudden discovering that there's a huge pot, 300,000 gone. And so we essentially quantified how much had been taken. But it was quite curious because the evidence all provided by the hotel was this gentleman walking over to the bar, putting his hand in the till, taking the money out of the till, walking over to front desk, doing his false accounting to conceal the theft, and then walking out the door. And so very, very brazen. And lots of sort of complicated accounting mechanisms in there as well. But from an investigations point of view, firstly, I need to sit with a lawyer, legal advice, understand what exactly are we trying to prove, and then gather the evidence for those points to prove. So certainly there's false accounting elements there. There is theft elements there. There is probably fraud in the sort of legal definition there. There's probably Company Act offenses. There's probably money laundering offenses. So a whole range of different sort of criminal activity, criminal offenses that have been perpetrated by Mr. Suspect. And if you're willing to pay me $1 million, I can investigate all of them. So you really have to kind of work out actually what is the low-hanging fruit. What is going to get us success? As said, we had CCTV footage for 2 weeks because most sort of IT backup systems do a rolling basis and they don't retain things long term. And we had accounting records. So you instruct a forensic accountant to do the forensic accounting element, the investigation on the accounting records. And we produced witness statements, did the interviews of witnesses, and pulled it together a police package. Action fraud, surprisingly, someone picked it up, but it went to an assault officer. An officer who loves assault, likes investigating assault, likes having those conversations. Do I think, on the record, that officer understood anything I wrote in my witness statement? No. What do I think the motivation of the police officer was? Well, to get a conviction, no matter what the conviction is. So you've got 300K over 6 years. And the guy confessing to stealing 2,000 over 2 months, and the Crown Prosecution Service accepting that, and then the suspect having pled guilty, getting 50-odd hours of community service and a slap on the wrist, effectively. So you've got a situation there where you've got a very frustrated client, the hotel. You've got employees within the hotel who are not only have they had their trust in this person shattered, they're then seeing that there is no justice because, well, he's walking free, he gets no jail. I mean, 300K should, in my experience, get you 2 to 4 years, depending on the circumstances. But this guy got community service. So, you know, we did the right thing going to the police. We got interest from the police, but we didn't get the justice that we thought was deserved. I mean, there are possible remedies for this client going forward for the hotel group, depending on the structure of the confession. If he confessed to committing X amount of fraud in this period, then you might be able to go after him for the other period. But unfortunately, this case was just before the pandemic, and being a hotel, they didn't really do well with extra funds to carry forward the prosecution, even though there is a potential for recovery. It's that sort of initial cash injection that's needed, that might be needed depending on who you instruct. So that was kind of like the ugly side of going to the police. Carl and I are working on a nicer case.
Brendan, before you come on to that one, can I just touch, because there is a question here, and it's relevant to the example you just gave, actually, I think. Somebody's asked, isn't the power of default sentencing the Proceeds of Crime Act a useful deterrent not available in civil regime? What this question effectively means is, under the Proceeds of Crime Act, where somebody is found guilty, convicted of a criminal offence, there are powers available to the authorities, even if it is done by a private prosecution. If someone's convicted, there are powers available to the authorities to recover the proceeds of crime that have occurred as a result of that offence from the individual. Now, what Brendan is talking about here is, this is why it's relevant to his example, is because in his case, the amount that would have been recoverable would only have been £2,000. So this person has effectively got away with 298 or thereabouts £1,000, where the Proceeds of Crime Act can't recover that money. What is useful about this tool, and it's probably worth bearing in mind, because there are circumstances, and I have this quite a lot with clients, where the suspects, the people who have committed the offences against our clients, on paper don't have any money. So the money's either it's gone, or it's been moved around, or they've hidden it in trusts, which can be very, very frustrating through the civil proceedings. There is a useful tool within the Proceeds of Crime Act where if they are convicted and there is a confiscation order for, say, it's a £50,000 offence, or the £300,000 one that Brendan was talking about, if they are convicted, they'll have to explain where all that money has gone. And if the court can't be satisfied that all that money has been disseminated or gone or whatever, and they're going to have to prove that to the court can actually sentence them in default for the available amount that they believe should be there. Now, if it's hidden, it's for them to prove where it's gone, which can be very, very difficult for them. And they can get, I think, Chris, you might be able to correct me on this, but is it up to 12 years these days, I think, as a sentence in default?
Yeah, I mean, it is a very useful tool. It's a really good question, actually, from the audience, as it were. And the notion that you've just explained, Carl, about defendants having to prove their level of realisable assets is a live one in many, many confiscation hearings. Mm-hmm. And if the court doesn't believe what the defendant has to say about the level of his or her realisable assets, which could include, of course, the money which is said to have been stolen, then the court can make a confiscation order in a sum which includes that amount. It's called making a hidden assets order.
Hidden assets order, yes, exactly, yes.
Then it means that not only does the defendant have to pay over that enhanced sum of money, but it also means that the period of imprisonment which he would have to serve if he fails to pay it over is longer, because the greater the size of the confiscation order, the longer the sentence of imprisonment in default of payment.
Yeah, and I think it's something. It's changed, I think, the last few years, but it's around about £500,000 or above, or something like that, is about 12 years of custody. So it is quite draconian in terms of the way this can be used, but it is there and it is helpful. Once again, one of the reasons why prosecution is maybe helpful in instances where the other person has been quite devious and there's money, moving the money around, and you're getting frustrated. And if you do get the conviction, then it can be very difficult for them to prove where that money is gone. And if they can't prove it, as Chris has said, they could face a serious amount of time in prison, or will just have to find the money and pay it back,
which miraculously can happen. Can I just pick up on a separate point arising out of Brendan's example, just moving away from confiscation for a moment? I mean, it's obvious that in this case that the police performed very inadequately, and it's ridiculous really to have accepted a guilty plea to £2,000 when there were £300,000 on the table. But it can make for good prosecutorial strategy only to prosecute a certain fairly limited element of a much bigger, more wide-ranging fraud. Because the more you bite off, the more you've got to chew as a prosecutor, both in terms of presenting the case to a jury and also in terms of conducting the disclosure exercise that goes with it. So it's quite often the case, in fact, that a suspect or a group of suspects have committed a variety of different frauds, all against the same victim and all at the same time. But actually, what's quite good practice from a prosecution perspective is to say, well, actually, let's leave aside for a moment the money laundering and the theft. And we're going to just concentrate on those false accounting offences, because that's where we've got our best evidence. It's relatively simple. It's relatively self-contained. It's not going to lead to a sprawling disclosure exercise where we've got to consider hundreds of hard drives, mobile phones, iPads, conduct some massive digital exercise to ensure that we've complied with our disclosure obligations. And yes, if the defendants are convicted of that more limited range of offences, they'll get a shorter time in prison, but you've still secured a conviction, you've still sent them to prison. And after that, it is to an extent ever decreasing returns. So it's quite good practice, and it's quite good perhaps for your members to know that if confronted by what might appear to be an overwhelming landscape of offences and a really complicated factual matrix, it is possible within that to pick and choose the elements of it which you decide to prosecute.
Yeah, so in this case, the police went for the easiest to prove, which was supported by CCTV footage. So rather than rely or try and explain a forensic accountant's sort of opinion to the jury, I know we're complicated animals. So here's a CCTV footage with the suspects and his hand in the till. I think from a motivational point, from the hotel's point of view, it was really frustrating because this had a serious impact on the staff at the hotel. And from an owner's point of view and the staff point of view, they wanted to demonstrate two things: A, that there was a sense of justice in the world, and B, that they took these kind of activities seriously. And they failed on both cases because they went through the police. I think had this been done privately, the argument would have been structured in such a way which would have encouraged perhaps the CPS or the suspect who might have admitted guilt to a larger amount, whereas the police, it's outside of the control of the investigator if you hand it over to the police. I appreciate that we've got limited time, so hopefully just kind of touch on the case that Kyle and I are working on. This is an external fraud where an investee, a retail limited, I'll call them, provided false information in order to induce the investor to invest in it. So we're a fantastic business. We're doing very well. We've got positive trends in our sales, positive trends in our margins. Please give us more money so we can invest that in equipment, open some new stores up, and we'll do wonderful, amazing things. Lo and behold, our client gives 5 million, and then it disappears into a dark abyss. And then sort of 6 months later, company files for bank liquidation administration. And then we're sitting with the investor saying, where's my money gone to? The company and the directors have basically got away with murder, well, in figurative senses. So there's quite a lot of challenging aspects to this sort of case. Number one being, we're helping the investor. The investor has very limited evidence to support the case. So, Kyle and I sit together, we work out what the points to prove are, and then we start working out, well, who do we think has got the evidence? So the investor will have all the sort of representations made to it from the suspect. Those will be emails, business cases, projections, etc., etc., etc. Management accounts, audited accounts, and all these wonderful sort of financial information, which again makes accountants happy, but not necessarily the lay person looking at these details. Then Carl and I kind of, all right, how are we going to get information from the bank? How are we going to get information from insolvency practitioners? How are we going to get information from creditors? How are we going to get information from auditors and the liquidators and the directors itself? Because that, whilst we might have the misrepresentation part of the criminal offense that we need to try and prove, we still need to work out if there was dishonesty and various other aspects. So the more evidence we can pull together, the better to support the case. And Carl, I don't know if you want to kind of touch on that sort of Norwich Pharma issues.
Probably is worth mentioning that one of the issues, obviously, is we're not the police. We don't have the power to go up with a warrant and to go in and raid the premises and take what we want. But there are powers that are available to us that do allow us to recover materials from those who are caught up in the wrongdoing. It's something called a Norwich Pharma order. Some of the lawyers on here will be familiar with this, as will other people who have been involved with litigation, no doubt. But that Norwich Pharma effectively allows you to go to those who are innocently caught up in the wrongdoings. For example, in the bank, in this case, they're innocently caught up because the money has flown through the bank. Money that's been defrauded from us, but it's flown through the bank into the hands of the beneficiary. So they're innocently caught up. So we can get an order from the court to require the bank to disclose the information that we need from the bank or whatever third party it is that we've targeted in order to help us to get evidence of the wrongdoing. And we will frequently do this. So in this particular case, I already have one against the bank. I'm getting flooded with information that is extremely helpful and effectively is helping prove what we need. And there are various other targets as creditors, other people that we are targeting. And these institutions, they're not against giving this material. They just want a court order to say, oh, I've got the authority to do it. Otherwise, are we...
You need to ask for it in the right way, isn't it? So
ask for it in the right way. Otherwise,
yeah.
are they doing some sort of data protection breach or something? They're worried about handing over information. But once you've got that court order, they're quite happy. So they don't tend to be sort of argumentative about that. So I'm not going to say they're easy to get. There are rules in relation to how you can get the information. But provided you can demonstrate that you're the victim of crime and it's not a fishing expedition, you can show that this person ought to have the material, then it's a good power and an effective power to help do the investigation. And that's what we're currently working on.
So quick question in the chat, maybe Carl, I'll put this to you to start with. Have you ever been successful going through another authority like HMRC, for example, if you know a person's income is higher than declared? So in that kind of scenario, going on the tax side or another route?
So HMRC, another one who do investigate fraud, but on perhaps more down the sort of tax evasion sort of area. So we have had experience of liaising with HMRC where people have been the victims. I think a lot of these issues, HMRC a bit more proactive around the area that they do investigate, I have to say, compared to, say, the police, because it's kind of more assured about what it is that they're meant to be investigating. So if it falls into their remit, for example, tax evasion, then they will, or VAT fraud, etc. So they are a little bit more onto it. One of the things I would say is, outside of the private prosecution world, and maybe just one thing before we finish, it's important as well that if you do report the matter to the authorities, to do so, if you can, with the assistance of someone who can talk their language and make it as difficult as possible for them to refuse to investigate. By that, I mean, we have a lot of success in trying to get the authorities to get engaged by taking the witness statements, doing that part of the investigation for them, getting the main bits of the evidence, and then just writing an advice that just says a fraud has occurred. We can see that there is evidence of this. Now you must investigate. Makes it very difficult for the authorities at the CPS to refuse to investigate in those circumstances. So there are still occasions where that might be the better route. I've got a client right now who was deciding between a private prosecution and the police. He chose the police because he felt as though in this case, he wasn't the only victim. And he felt as though that the police just had greater powers to help all the other individuals who had been defrauded by this person. If it was just him alone, he would have done a private prosecution. But he just felt as though there were other victims. And if he just brought the prosecution on his own, he wouldn't get the support of those victims. And therefore, this person would get away with a much greater fraud. So there are circumstances, but I just wanted to mention that.
Thanks. Brendan, was there anything more from your example? We're just coming towards the end of the hour. We're going to wrap up shortly, but was there anything else further that you'd like to add on those two interesting illustrative examples?
Yeah, I think, as Chris said, we could talk for hours on this. So being very conscious of time, very happy to take questions offline. David, if you want to kind of forward them to me or via LinkedIn. The one thing I would just caution about sort of fraud investigations, economic crime, it's never just one thing. If you find one, someone's stolen 100 quid, it's very likely to be bigger than that. And it's never just theft. There's always another possible element that can be wrapped in as part of that sort of criminality. It's I could talk forever.
Okay, thank you. But the importance of picking up the phone and seeking expert advice and support where you it's all available. Christopher, any closing thoughts or comments, and then I'll come to Kyle for the final word.
No, not from me. Thank you. I know it's been very informative for me as well. I've enjoyed it. Thanks, David.
Brilliant. Terrific. Well, thank you for your insight. It was terrific. Kyle, closing comments as we wrap up this hour.
The key takeaways, I would say, are respond quickly. Don't sort of, procrastinate. If it is anything to do with the bank, contact the bank immediately. But if you have reliable lawyers that if not, there's There's a couple on the stage today that you can contact, but there are plenty out there who are there to assist you. But contact them as soon as possible. There's nothing worse than hear about things, a week or 2 weeks after the MAF, where it gets more difficult to be able to do things. Not impossible, but more difficult. But yeah, certainly there are resources there. And as Brendan said as well, if anybody has any further follow-up questions, I'm sure we're all more than happy to help out.
Terrific. Well, look, thank you, gentlemen, for your insight today. Thank you for tuning in. Thanks for your questions. Some excellent ones in there. And I hope you tune in next time. Thank you.
Thank you, David. Thank you, everyone.